Okay, Mr. Paul, is the parties, are they absent? Present, sorry.
The claimant is present, giving details of the Zoom meeting, my lord.
Okay. Let me record. Claimant present. Defendant absent.
Yes, my lord, defendant is absent.
Okay. So, Mr. Paul and Mr. Opara, this is my ruling.
Okay, my lord.
By a motion on notice dated the 15th of July 2025 and filed on the 16th of July 2025, the claimant applicant praised this honorable court for the following reliefs. Number one, an order of this honorable court for leave to amend the claimant's amended statement of general form of complaint, statement of fact, witness statement on oath, list of document and other processes dated 15th of October 2021 and filed on the 18th of October 2021 in the manner highlighted and shown in the proposed amended attached marked Exhibit A. Number two, an order of this honorable court deeming the claimant's amended general form of complaint, amended statement of fact, witness statement on oath, amended list of documents, and all amended processes already filed as properly filed and served. And for such, number three, for such further orders at the honorable court may deem fit to make in the circumstance. The motion is supported by a 9-paragraph affidavit deposed to by the counsel representing the claimant. The proposed amended statement of fact was attached to the affidavit as Exhibit A. A written address of counsel was also caused to be filed to accompany the application. It was about in the affidavit in support of the application that the proposed amendment is intended to bring the claimant's claims into agreement with the statement of fact, witness statement on oath, and other processes already before the court. The application seeks to bring evidence in line with the pleadings. It was also about that the defendant respondent would not be prejudiced by the grant of the application. In his written address, learned counsel for the applicant, formulated a sole issue for determination, namely, and I quote, whether in the circumstance of this case, this application ought to be granted to enable the claimant applicant better present the fact of his case and bring his evidence in line with the pleadings before this honorable court, unquote. Chief Paul, learned counsel for the claimant, relied on the case of Chief of Defense Staff and Akeba for the proposition that an application for amendment is the right of a party to present his case in the manner that appears best to it, once it does not occasion injustice to the other party. It is also submitted that it is only where an amendment would prejudice the other party to the extent of occasioning injustice that the court will refuse it. Counsel cited the case of Lagura and Toku. Counsel therefore urged the court to grant the claimant's relief as sought. Defendant counter affidavit. In opposing the application, the defendant filed a 7-paragraph counter affidavit and a written address of 12th of May 2026, where it was averred in the counter affidavit that the amendment sought to be made by the claimant is intended to overreach the defendant, and if the application is allowed, the defendant will be prejudiced greatly. In the written address, learned counsel for the respondent formulated a sole issue for determination to it, and I quote, whether under the circumstance the proposed amendment which the claimant seeks to make to his pleadings ought to be allowed at this stage of the proceedings and for the third time, unquote. It was submitted by counsel that by virtue of Order 26 Rule 2 of the rules of this court, a party may amend its written and other processes at any time, but not more than twice, with leave of court. And the claimant having amended his original process twice, first on 25th of May 2014 and again on 18th of October 2021, following a change of counsel, the present application seeking leave for a third amendment is therefore contrary to the express prohibitions of the rules of court. Counsel stated that trial was concluded and final written addresses were filed and exchanged as far back as 2022 to 2023. The defendant's final written address was filed on the 7th day of December 2022, while the claimant's final address was filed on the 23rd of January 2023. And the defendant's reply on points of law was also filed on the 14th of March 2023. The present application was filed in July 2025, which clearly comes more than 2 years after the conclusion of evidence and the filing of final written address, and more than 11 years after the commencement of this suit in 2014. Thus, granting the application will be prejudicial to the defendant. Counsel placed reliance on the Supreme Court case of Akanwo and Insri, Patobi JSC, that an amendment must be shown to be brought in good faith. Counsel, having regard to the attitude of the parties, nature of the amendment, and the question in controversy, and the time at which the amendment is sought. It was also submitted that amendment at a late stage of the proceeding, unsupported by evidence or record, ought not be granted. Citing the case of B.O. Okafor and African Continental Bank Limited, counsel concluded that the application not made in good faith is an attempt to overreach the defendant and amounts to an abuse of court process as provided by Order 26, Rule 1 and 2 of the rules of this court. It was contended that the proposed amendment introduces over 60 new paragraphs to the statement of fact, 15 new reliefs, including declaratory reliefs, an additional monetary claim of approximately 1 billion naira. Accordingly, the defense submitted that this is not a mere tidying of pleadings to align with existing evidence, but the introduction of an entirely new course of action. And from the proposed amendment, the claimant is changing the course of action to a banker-customer relationship claim, which is superimposed on what has for over a decade been a claim founded on wrongful termination of employment. The defendant contends that granting the application would necessitate reopening a concluded trial, compel the defendant to respond to the new course of action, banker-customer relationship that will occasion a miscarriage of justice. Defendant further contended that such an amendment offends Order 26, Rule 1 and 2, Rule 1 sub Rule 2 of the rules of this court, which enjoins the court to refuse an amendment that would present a completely different case or cause injustice to the other party or is brought malafide, necessitate the hearing of further evidence, especially at a late stage, or amount to overreaching the other party or an abuse of court process. Claimant filed a reply on points of law to the defendant counter affidavit and further submitted that the court retains the discretionary power under Order 26, Rule 1, sub Rule 1 of the rules of this court to grant the amendment sought. Counsel also contended that none of the grounds for refusal under Order 26, Rule 1 and 2 is present, and that the amendment was not brought malafide. Counsel distinguished the case of Chief Adebayo Adedapo Adeke and Chief Obi Akin as inapplicable to the instant case. In the trial court, in the latter case lacked jurisdiction to attain the subject matter sought to be introduced by the amendment, which bordered on employment. Council then relies on the recent Supreme Court case of Elegbe and HP International Schools as having settled that this court has jurisdiction over matters of the character sought to be introduced by the amendment. So this is my opinion. Having gone through the processes filed by the parties and the respective submissions, the issue I will address is whether there are sufficient grounds to grant the applicant's motion for amendment at this stage of the proceedings. Let me quickly observe that this case was instituted on February 12, 2014, and first came up for mention on April 29, 2014, before Honorable Justice Bibi Kanyi, now the president of the court. The claimant then filed an amendment application for amendment on 17th of March 2015, but withdrew it on May 14, 2015. A similar withdrawal occurred on 2nd of March 2016 concerning a motion for amendment filed on June 3, 2015. However, on that same date, the claimant moved a separate amendment motion filed on 8th of July 2015, which was granted. After the claimant served the defendant the amended statement of facts, the defendant was granted leave on June 9, 2016 to file a consequential amended statement of defense, which was subsequently filed on 8th of June 2016. When Honorable Justice A.N. Obaka took over the matter, claimant's motion for amendment filed on 29th of March 2017 was also granted on the 10th of October 2017. When the case was transferred to Honorable Justice Mustafa Tijani, another amendment motion dated list of documents filed on November 12, 2018. Finally, upon my presiding over the matter, the claimant counsel moved two motions on October 26, 2021, one for a change of counsel and the other one for further amendment, both of which were granted as prayed. On 16th of May 2022, the defendant made a consequential amendment to assessment of defense, which was dated 5th of May 2022 and filed on the 6th of May 2022. Pleadings were then closed, and the hearing in the case commenced on the said day, that's 16th of May 2022, when the claimant gave evidence and closed his case on 28th of September 2022. Thereafter, the defendant opened his case on 26th of October 2022 and closed same on 26th of October 2022. The matter was then adjourned to 25th January 2023 for adoption of final written addresses. Defendant counsel filed his final written address on 7th of December 2022, while the claimant also filed his final written address on 3rd of January 2023 in response to the claimant's final written address. The defendant then filed his reply on points of law on 14th of March 2023. On 25th of January 2023, the day set for adoption of final written addresses, the defendant brought an application to regularize its final written address. As a result, the case was adjourned to 28th of March 2023 for adoption of final written address. Meanwhile, the claimant filed his instant motion on 16th of July 2025. In determining this application, I wish to refer to Order 26, rules 1, 2, and 3 of the rules of this honorable court, which states as follows. An amendment may be allowed where its purpose is to determine the real question or issues between the parties and would A, secure substantial justice, or B, settle the controversy between the parties or related issues. Number 2, an amendment may be refused where it would A, present a completely different case or cause injustice to the other party, or where the application for amendment is brought malified. B, necessitate the hearing of further evidence, especially on appeal, C, not cure the defect in the procedure sought to be cured, where it is inconsistent and useless. And D, amount of overreaching the other party on an abuse of court process. Number 2, a party may at any time, but before more than twice, with leave of court, alter, amend, or modify the party's originating and or other processes, provided that the party may not completely change the course of action endorsed on the process. Number 3, the court may at any time and on such terms as to cost or otherwise as the court or judge may think just, allow a party to amend any defect or error in any process. And all necessary amendments shall be made for the purpose of determining the real question or issues in controversy raised by or arising from the proceedings on court. Generally, amendments of pleadings are inevitable because humans are generally fallible. It's not unusual to make mistakes and seek to correct them even in the most thought out cases. And so courts oftentimes bend backwards to accommodate litigants who desire to amend pleadings, especially when the objective is to bring them in line with the evidence. See the case of Diamond Bank Limited and Rancasa Enterprises. It is the law that in civil cases, a party is entitled to amend his pleadings so as to enable the trial court decide the real issue or issues in controversy between the parties. See the cases of Salami and OK and Fountain Links Limited and Ubo. However, an amendment can be refused where it is made malified, or if the proposed amendment will cause unnecessary delay, or will in any way unfairly prejudice the opposite party, or is quite irrelevant or is useless. See the case of Adeke and Akin, and Ashamo and Bando. The principle of law is well settled that the purpose for allowing amendment is to enable the parties to conduct their cases properly by placing before the court all relevant facts necessary for the just determination of dispute between them. But any application which seeks to either overreach the other party or alter the nature of the applicant's case will not be allowed. An amendment will hardly be refused if it will enhance the justice of the case, except it appears in the opinion of the court that there is a fraudulent intention or a hidden agenda, which will generally work injustice against the opponent. See the case of Compagnie Generale de Geophysique and Jumbo. The power of a court to grant leave to amend is discretionary, and since it is entirely a matter that resides in the discretionary jurisdiction of the court, such exercise of discretion must be seen to be exercised judicially and judiciously. See the case of Ogidi and Egeba. Different considerations attend the exercise of that discretion depending on the state at which the application is brought. See the case of Kafwa and Ekeny. The overriding test is whether the amendment is required to determine the real question in controversy between the parties, and whether it can be granted without occasioning an injustice which an award of costs cannot atone to. See the case of Adeki and Akin. While the circumstances in which the application is brought make it difficult for the court to exercise its discretion judicially and judiciously in the interest of both parties, the application ought to fail. See the case of Bendel Insurance and BCN Finance Limited. I agree with the principle relied upon by the learned counsel for the applicant in chief of defense staff that an application for an amendment is within the right of the parties in action. However, amendment of pleadings cannot be open-ended, especially where it appears that the applicant anticipated the case of the respondent and seek the amendment to frustrate the case of the respondent. Then such amendment should not be allowed because in all likelihood, such amendment cannot be redressed by cost. See the case of Diamond Bank and Rancasa Enterprises. An amendment can indeed be granted in some cases, even where any issues appear to be introduced. But that is with the caveat that the internal amendment brings pleadings in line with the evidence already laid. But if the amendment introduces completely different issues with the potential for adducing new evidence on both sides and prejudicial as a consequence, then such amendment cannot be granted in the interest of justice. See the case of CCG Nigeria Limited and Idoren. In the instance case, an An examination of the application and the proposed amended processes shows that the claimant is also seeking to file another witness statement on oath and to bring in additional documents by amending the list of documents. Although the claimant has not asked for an order to reopen the case, but the implication is that when the witness statement on oath and the additional documents are introduced, the claimant will reopen their case. This case is already closed and is at the stage of adoption of final written addresses. To allow the claimant to do this will necessitate the defendant to further amend, reopen its defense, and recall witnesses. I think there must be an end to litigation. See the case of Anyimba and Onovo and a Castro West local government versus Christopher. I also observed from the particulars of the amendment and the proposed further amended statement of fact that what the claimant wants to introduce into the case by the amendment is far more than the reasons he gave for the amendment. New facts and materials are intended to be introduced into the matter. Most importantly, the claims sought on the amended statement of fact have also been altered in the proposed amendment. These new matters have the effect of changing the color of the case at this late stage of the proceedings. The amendment sought is not to bring the pleadings in line with the evidence or to plead facts already in evidence. The amendment sought is meant to plead new fact and reopen the claimant's case to prove the new fact. Courts are usually circumspect in granting amendments where the amendment will require further evidence to be adduced, especially where parties have closed their cases. Although this court has the discretion to allow amendments or pleadings of the parties at any stage of the proceeding, but such discretion is not exercised as a matter of course. The court will usually not grant leave to amend pleadings where the application for amendment is made malified if it will entail injustice to the other party, if the proposed amendment will cause undue delay, or is irrelevant or useless, or merely raises a technical point. If the amendment has done some injury to the respondent which cannot be compensated for by cost, if the application is designed to overreach the respondent, and if the amendment will result in a party being confronted with an entirely new case at an extremely late stage of the trial, or is in conflict with the evidence already given in the trial. See the case of Adeke and Olubade, Akinwo and Insirim, Nigerian Dynamic Limited and Dumbai, Kalu and Uge, Nigerian Dynamic and Dumbai. See also Order 26, Rule 1, Sub-Rule 2 of the rules of this court. I agree with the defendant's argument that this proposed amendment goes far beyond a mere procedural cleanup. It introduces over 60 new factual averments, 15 additional reliefs, including the creditary reliefs, and a substantial $1 billion in new monetary claims. It is also observed that the claimant is not simply refining the pleadings, but is fundamentally shifting the legal basis of the suit. After more than a decade of litigation centered on wrongful dismissal, the claimant now seeks to replace that course of action with one based on a banker-customer relationship. And granting this request will unfairly require the court to open a case that has already been tried, force the defendant to defend against an entirely new legal theory, and ultimately result in a serious miscarriage of justice. The application therefore seems to be directly cut by Order 26 Rule 1 Sub-Rule 2 of the rules of this court, which empowers the court to reject amendments that introduce a radically different case, cause injustice to the opposing party, are brought in bad faith, necessitate additional evidence at such a late stage, overreach the other side, or consider an abuse of judicial process. Having examined the circumstances of this case, particularly the state at which the application is brought and the nature of the amendment sought, it's clear to me that the amendment sought is not only overreaching, but it will cause undue delay and introduce an entirely new course of action in the proceedings. I'm therefore unable to find any valid reason or justification to grant the claimant's application. In fact, the factors to consider for refusing an application and amendment, as outlined in the authorities cited above and the rules of this court, are present in this case. Consequently, the application fails and is accordingly dismissed.
I'm most grateful, my lord.
Most grateful, my lord, for the well-considered ruling and the elucidation. Most grateful, my lord. My lord, in the circumstance, we'll be asking for costs. This application cost us so much. Most grateful, my lord.
My lord.
Mr. Paul.
Yeah, my lord, we concede to cost of 50,000.
Okay.
My lord.
Yes, Mr. Paul.
In the circumstance of the case, I don't know if we can plead for His Lordship indulgence for us to adopt the final written address thereafter.
No, we'll adopt we'll just fix a date in October when you come back from the vacation. Then God willing, before the end of the year, I'll deliver the judgment.
At the court, please.
Check whether 22nd of October is okay. Because we're going to be having our legal year by the first week of
22nd of October.
Yeah, 2 years.
It's convenient, my lord.
Okay. Mr. Opara.
Yes, my lord. 22nd of October is a Thursday. It's convenient for now, my lord.
It's virtual.
At the court, please. Most grateful, my lord.
So, Mr. Paul and Para, the 22nd is okay, ma?
Yes, my lord.
Yes, my lord, if convenient, my lord.
Okay, we'll send you the link. So, given the circumstance, cases are adjourned to the 2nd of October 2026 for adoption of final written addresses with a cost of 50,000 naira granted in favor of the defendant respondent.
The court pleases. We are most grateful, my lord.
Thank
Most
you.
grateful. Thank you, my lord.
The two chiefs, Chief Paul and Chief Opara, thank you so much. I appreciate that. I appreciate you.
Thank you, man. Thank
Thank
you,
you. Thank you, my lord.
Thank you. Yes, Mr. Aywa.
Yes, my lord.
Mr.
Yes, my
you
lord.
are for the
Defendant. For the defendant, Mr. Ugona
Okay.
Uchefu.
Okay. So parties absent.
Yes, my
Parties
lord, the
absent.
defendant is absent.
But it's like I okay, hand. Mary, you said Mary?
Omotayo Okere.
Okay, Omotayo.
Okere.
Omotayo. Omotayo. Okay.
For the claimants, my lord.
For the claimant, yes.
Yes, my lord.
Mr.
Te Lumo Ayua.
Telu.
Okay.
Yes, Mr. Ayua.
Yes, my lord.
The matter is for adoption.
Yes, my lord.
Is there any pending motion?
Was it?
Yes, the pending motion filed by the defendant's counsel. Let me see whether it was taken. Okay, it was taken. Okay, it was taken.
Yes.
Your motion was taken.
Yes, my lord. Yes, my lord.
The matter is for adoption of binary written addresses, and we are ready. Okay, also ready.
Yes, my lord.
Yes, Mr. Ayua.
Yes, my lord.
Defendant's final address is dated and filed
On the 27th day of January 2023.
Okay, yes. 2023 years. Yes.
Yes, my Lord, we will seek to move in terms of our final written address.
We wish to adopt same as our
Final.
argument
Exactly.
and submission in urging the courts
We've got to grant them again.
to grant or to refuse
To grant,
Sorry.
to grant, to deny the
Okay.
claimant claims,
Refuse.
to dismiss,
Claimant. Okay.
to dismiss this suit in its entirety,
Okay.
same being frivolous and with substantial cost against the
Okay.
substantial cost in favor
Yes. Yes.
in favor of
That
the
okay. That's all.
yes, my lord.
Defendant.
Yes, my lord.
Okay. What was his offense that you took him to the police?
My lord.
Take him to the police. I said, what offense did the claimant commit to take him to the police?
Oh,
He was accused of the defendant. Yes, I think he was
My
accused
Lord,
of
it's,
organizing.
no, it's a breach of peace. If I
Hmm?
could be of assistance, it was the claimant that actually went to the police when he noticed that
Yes.
the defender wasn't paying him. But unfortunately, it was turned against him while he was the one that reported and he was still the one that was detained. He was charged for breach of
Okay.
peace.
Is that Omo? Sorry, is that Omotayo speaking?
Yes, 16, my lord.
Is that Omotayo speaking?
Yes, Omota
Okay,
is
he took
speaking, my
himself
lord.
to the police. He
The
took
claimant that
himself
went
to
to the
the
police, my
police.
lord. Yes.
yes, my lord.
Omotayo, I can't hear you well. Omotayo.
Yes, my lord. I can hear you loud and clear, my lord.
He took himself to the police.
Yes, he went to go and report at the police station when it was evident
Okay.
that so he was detained at the police stations.
Okay. Then if that's the case, it means he wasn't there at the instance of the defendant. He wasn't invited. He wasn't detained at the instance of the defendant.
Yes, my lord. If I may say something briefly, you're
Yes,
not the
yes,
my lord.
Yes,
Yes, my lord. Before the claimant went to the police station, while he was in the employment of the defendant, he collected money as a
Yes.
principal, if I can recall the fact. As a principal, he collected money from some other students which were in the defendant school, collected money from
Yes.
their parent to enroll them for JSSC, junior WAEC exam, and SSC WAEC exam. So, and he failed to enroll them for the examination. So the parent came to the school. The parent came to the school, and when the defendant got notice of it, they all went together with the parent and reported to the police station. and the police were looking for the defendant. Fortunately, luckily, the defendant went to the station to report. That was how the police arrested them, based on the statement of the parent and the defendant. If I'm not mistaken, my lord, I believe we have tendered the CTC of the parent and the defendant statement at the police station. That was what transferred. So when the claimant got to the station, based on the report, the complaint of the parent and the defendant, that was why he was arrested. Before he went to the station, there was a complaint against him at the police station.
By who?
By the parent and the defendant himself.
Okay. Okay. They lodged a complaint against him to the police for what? What the complaint is.
Yes, well, I'm trying to look at it was for collecting money from those, I believe, extortion, collecting money from the parent without enrolling their children.
Okay, and he was taken to court.
Yes, he was taken
to court.
Yes, he was.
And
my lord, yes, my lord, he was charged to court. But I believe,
and he was discharged. The case wasn't proven. He was discharged.
It was discharged or withdrawn. It was withdrawn, I believe, my lord.
Because one of his claims is the claim of malicious prosecution.
Yes, my lord.
Yes, malicious prosecution. So it means he was detained at the instance of the defendant and the parents.
Yes, my lord. The defendant make a complaint to the police and the parent, and based on the police investigation, they detain him and charge him to the court. He was charged to court based on police investigation, and
but he was subsequently discharged. He was later discharged, and is he discharged or acquitted or something?
It was not acquitted. It was discharged based on the withdrawal. We did not. The claimant did not tender the ruling or the order, the charge sheet. We were the one that tendered the so.
But it's before the court now. You even tendered it. He tendered the discharge certificate, discharge proceedings.
Asco, please.
You tender what? The charge sheet and the discharge proceedings?
We tendered the charge sheet, my lord, and his statement, the claimant statement at the police station.
But Mr. Ayoa, he was charged with an offense of said, did conduct yourself in a manner likely to cause breach of the peace by registering 3 students from the unique something. That's his count 1. Count 2, that you Victor Alpha so did tell one Ugonna Isefu through text message that before he killed a deeper life pastor at Monkey Village, Lagos, that he blackmailed him and also called Oguna Echefu and a occultic man, and thereby committed an offense punishable under. So these are the charges. But he was later, but he was later discharged.
Asco, please.
He was later discharged. Okay. So, Mr. Aria, you urge the court to dismiss the claimant's claims.
Yes, my
Right?
lord. Yes, my lord.
Okay. Yes, and okay, Ray. Yes,
Yes,
okay,
may it please the
okay.
court. Claimant's final written address is dated the 16th February 2023, my lord.
And dated when? Same date? No, dated on the 14th. It's dated
14th February
14th
2023, my lord.
February 2023, but filed on the 16th
16th of February 2023.
Yes. 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 Yes, Omota areas. Yes, Omota areas.
My lord, we formulated only one issue for. I can hear you, my lord. You can't hear me.
Go on.
Can you hear me,
Yes.
my lord?
I can hear you.
Okay. Our written address, we formulated only one issue.
One issue.
Formulated one issue, yes, my lord.
For determination is?
Yes, my lord. Whether having regard to the evidence that the claimant has proved his case as to entitle him to judgment in this suit.
Yes.
My lord, then we perform arguments to it. And my lord, will be adopting the same as our evidence and arguments in this matter. And we urge your lordship, we submit that the evidence led by the claimant in the proof of this case against has established that the claimant is entitled to the relief sought in his statement of claim. So we therefore urge my lord to uphold this suit and rule in favor of the claimant, my lord.
Okay.
My lord, a little, just to adumbrate for just a few seconds.
Yes.
My lord, the brief of this is that the claimant was employed by the defendant sometime in January from 2018 to 2019. And
Yes.
it was at the same time promoted at the time to be the acting principal, vice principal in school for that period. So both of them are good until the time of the wages when it appeared that the defender was owing the claimant his wages. And in that, he demanded for his payments. And that was when the defender could not get it, He just turned an adversary against the claimant. And so because the defendant has some connections and that, so the claimant not to take the law into his hand had to go and report at the police station. Unfortunately, while he got there, it was turned against him. We believe that if there has been any issue with the parents, they will have come to give the defendant out all the opportunity to call the parents, come and give him for over 2 months before he could perfect it. And after, when he was discharged, the defendant never appeared to give evidence in that matter for trial. That was how the matter was withdrew.
Okay.
So it's based on that the claimant instituted this his wages were not paid, and at the same time he was maliciously prosecuted.
Yes.
We urge the court to grant all our relief in this matter and give the claimant
But what about the dismissal? It's like you're saying that the dismissal was an afterthought. Is that so?
Yes, my lord. If you look at the dates, even in evidence, the defendant could not juxtapose the dates of the dismissal. It was an afterthought. These were people that were going on well. I'm trying to reach to that evidence, my lord.
But you didn't ask for any relief. You know, as regards to
my lord.
Dismissal, you didn't.
So what we're just asking is the salary in lieu of notice of termination. That was what we're asking for.
Salary in lieu of notice. So charges.
Yes. So charges that was what we asked for.
The salary in lieu of notice is 24,000 naira. Is that so?
Yes, my lord.
Okay. His salary for March, I think for March.
Yes, when the incident happened, because he actually worked.
Okay, but
that's 33,000.
But this service charge for SSC class and junior WAEC, is there any document showing that he was?
But that's just it. There is no. But it was an implied time. So it was an implied agreement. There is no stated document, but the defender was very much aware of it.
And did you call any other person to come and corroborate his evidence?
No. In this one, we did not, my lord. It was difficult because the children of those of the parents were still the children are still students of the defendant school, so many of them are not they were ready to talk from behind, but they couldn't bring themselves forward to the defender. Is a powerful man.
It's okay. I will look at everything, God willing, and we'll communicate the date for judgment to you.
Yes, I will be grateful, my lord. This claimant has suffered. He's an hardworking man that puts all his best. Was taking like 6, 7, 8 classes, and yet he's still being deprived of his wages. Still locked up at the same time. The most grateful, my lord, if all our
you ask for, Omota, you asked for salary in lieu of notice of termination of employment being 24,000 naira. One of your reliefs is salary in lieu. Salary in lieu, but you didn't ask for.
Yes, my lord.
I say you asked for salary in lieu of the termination.
And that should be like specific. Yes, my lord.
You asked for salary, but you didn't ask for any damages.
Or that special damages. I asked for damages, but I didn't ask for damages.
No, not the damages
in respect of that salary.
For the issue of the malicious prosecution and the unlawful denial of claimant wages. That's just the damages you have asked for. You didn't ask for damages against the termination. That's in the event the termination is even found to be wrongful. In any case, I will look at everything.
Ask up, please.
That would be that would be omnibus prayer, my lord. My lord will grant us that. Thank you, my lord.
It has to be, something specific.
Ask up.
You have to,
ask up, please.
Ask up, please.
Yeah. So, is there any other thing, Omotayo? For the adumbration,
no, my lord,
are you done?
That will be all. Yes, my lord, I'm done for the adumbration. They didn't file any reply on points of law. of your my Lord.
Okay. Okay.
I just seek my Lord to grant us all our
Reliefs.
reliefs. Yes, my Lord.
Okay. So, given the circumstance, cases are adjourned to a date to be communicated to council for judgment.
As God
As God
pleases.
places.
So, Mr. Ayuwa and Omotayo Okere,
Yes, my Lord.
that's all for today. I wish you good afternoon.
Thank you, my Lord.
Thank you, my Lord.
Except you.
Thank you.
And we also wish you a good holiday, my Lord. So we'll
Thank
see
you.
you in October.
I hope you're also going to rest too.
Yes, we are going to do that.
Yes.
You may have other magistrate course and other things.
Yes,
In
my
any
Lord.
case, it's still okay. I also wish you the same.
Thank you, my Lord.
Thank you.
In the absence of any other thing, I leave.